Hello everyone and welcome back to our YouTube channel. Please hit like and subscribe to keep up to date with our content. Today we're talking about issues surrounding the liability for slip and fall accidents on public and private property. We've all been to places like grocery stores, shopping malls, or even walked along city sidewalks without giving much thought to our safety. But accidents can happen when we least expect them, and understanding who is responsible can be a bit tricky. So today I want to unpack the responsibilities of property owners, both private and public, for injuries that occur on their premises. Let's start by talking about premises liability. In simple terms, premises liability refers to the legal responsibility that property owners and occupiers have to ensure their property is reasonably safe for visitors. This means addressing potential hazards like wet floors, uneven surfaces, poor lighting, or anything else that could cause someone to slip, trip, or fall. In North Carolina, if you're injured on someone else's property due to a hazardous condition that the owner knew or should have known about, you may have the right to seek compensation for your injuries. But, as with many legal matters, it's not always straightforward. So we recommend that you consult with an experienced personal injury law firm, a law firm licensed and located in your state. Now let's delve into accidents that occur on private property, like retail stores or other businesses. Business owners have a duty to maintain a safe environment for their customers. This includes regular inspections to identify and fix potential hazards, proper signage to warn of any dangers, and prompt responses to issues like spills or broken fixtures. Suppose you slip on a puddle in a grocery store aisle because an employee failed to clean up a spill in a reasonable amount of time. In that case, the store may be held liable for your injuries. However, if the hazard was obvious, or if you were not paying attention, issues such as contributory negligence could come into play. So talk with your attorney about how your being at partial fault might affect a compensation claim. Now let's consider accidents on city property, such as public spaces and sidewalks. Municipalities are responsible for maintaining public areas and ensuring they are safe for use. If you're injured due to a poorly maintained sidewalk, like a raised slab or a pothole, you might have a claim against the city. However, pursuing a claim against a government entity can be more complex than dealing with a private business. There are often specific procedures and shorter time frames, sometimes called notice periods, that you must adhere to when filing a claim against a city or county. Missing these deadlines can result in losing your right to seek compensation altogether. Moreover, governmental entities may have certain immunities that protect them from liability in some situations. It's essential to consult with an attorney who understands these nuances to navigate the process effectively. Understanding the types of compensation you might be entitled to is also important. Generally, compensation can cover various aspects relating to your accident and injury. First, there are medical expenses, which include the cost of emergency care, hospital stays, surgeries, medication, rehabilitation, and any future medical needs related to the injury. Then there's lost wages. If your injury causes you to miss work, you may be compensated for the income you've lost. This can also extend to future earning capacity if you're unable to return to your job or if your ability to work is diminished. Pain and suffering is another category, accounting for the physical pain and emotional distress you've endured as a result of the accident. In rare cases where the property owner's conduct was especially egregious, the court might award punitive damages to punish the wrongdoer and deter similar behavior in the future. Navigating a slip and fall claim can be overwhelming, especially when dealing with injuries and recovery, but a good attorney can remove the strain and handle it on your behalf. When it comes to the differences in the claims process between private property and public or city property, timing and procedures are key distinctions. For private property incidents, you typically file a claim with the property owner's insurance company. The process involves investigating the incident, proving negligence, and negotiating a settlement or taking the case to court if necessary. For accidents on city property, the process often requires filing a formal notice of claim within a specific period, sometimes as short as 6 months from the date of the accident. Failing to file this notice on time can bar you from pursuing compensation. Additionally, the standards for proving negligence can be higher when dealing with government entities, and there may be caps on the amount of damages you can recover. Understanding these nuances underscores the importance of seeking legal guidance promptly after an accident. Time is of the essence, and the sooner you act, the better your chances of a successful outcome. In closing, slip and fall accidents can have serious consequences, affecting your health, finances, and overall well-being. Property owners, whether private businesses or public entities, have a responsibility to maintain safe premises. If you or a loved one has been injured in a slip and fall accident, don't hesitate to reach out for professional legal advice. An experienced attorney can help you understand your options, gather the necessary evidence, and advocate on your behalf. Thank you for joining me today. I hope this discussion has shed light on the intricacies of premises liability and how it applies to slip and fall accidents. Stay safe out there, and remember, knowledge is power when it comes to protecting your rights. Please hit the like button and subscribe to our channel for future updates, and visit our website at kellumlawfirm.com.